right, so now that we're back on, another thing you need to remember is child support orders run until the child turns 18, or if enrolled in school at the time. And when I say enrolled in school, the child could still be in high school, or the child could be in college, and then the order will continue if you ask for it in the beginning, or you can seek a variation when the child is 17. But do not wait till your child turns 18 to realize, hey, I don't have in place an order that speaks to until my child finishes college. All right. Additionally, I've had a case recently where I had to explain to a mother that she's entitled to child support for this child's life, and not until 18. And the difference was the child had a mental issue, mental disability. And with that, there's a section in the Child Protection Act that speaks to maintaining this child for life. And we secured the order in court in a very heated matter back and forth that the father would have to contribute for the rest of this child's life. So the child could be 40 years old and daddy could be 60. He'll still be contributing towards the medical and the maintenance, dental expenses of that 40-year-old young man in the future, all right? So Section 53 of the Child Protection Act states that the court or the judge's decision-making process is guided by certain things. So the judge isn't just willy-nilly come into court and says, hey, okay, well, you're going to pay 100, this person's going to pay 50, this one's going to pay 25. It is based on a few things, and those things are the income and earning capacity. So if you have a mother who comes to court for child support and she's making $75,000 a year, for instance, and then the father of a child comes to court and he's making $20,000 a year, and vice versa, then the magistrate will look at their income and earning capacity and say, well, in this scenario, unfortunately, while each of you should be contributing equally, ma'am, your means is much higher, so you are able to pay 60% of this child's expenses, and the father will pay 40%, and vice versa. Another thing the court will look into is property and financial resources. So if you have a father that owns his house, he's not paying a mortgage, and then the mother who is paying rent, the court will also factor that in and say, well, then the father is in a better position than the mother in this scenario because she's defying rent every month, whereas this father does not. So his income for his expenses is light bill, water bill, phone bill, and that's it. Whereas the mother has rent, light bill, water bill, phone bill. She's dealing with the children for gas to take them to and from school every day. She's burning more electricity in the home because they're doing homework. She's using more water because the children are with her. The court will bear those things into consideration as well as the financial needs and obligations, responsibilities of the parents and the child. And the child. So in the case I mentioned a while ago, the child had some exceptional needs, physical, mental disabilities, so there were extra needs, and the court bears that in mind as well. Section 54 addresses the court orders when you don't pay, and the arrears applications would need to be taken out. So if the other party is not paying their child support, they're not contributing towards the educational, medical, dental expenses, they're not paying the child support when they're supposed to pay or in full, so they have an arrears, then 15 days after that court order, anytime after 15 days, up to, and I would say we're having this issue in law where you can't sit back for 3 years or more and not collect child support, and then when the child is 17, when they come to court and say, oh, he owes $100,000. What you would have proven to the court is that you didn't need the child support if you was able to take care of the child all these years without coming on an arrears summons. Then the court is unlikely to order that this father or the other person pay all the arrears that they owe you. So 15 days after the order is granted, this person has failed to make their payments on the 1st of the month and the 15th of the month, for instance, then you can come on day 15 and file an arrears summons saying that he was supposed to do X, Y, Z, he hasn't. If that father, for instance, does not appear on the arrears summons, the court can proceed in their absence. So the police has served that father with an arrears summons to appear before a court on the 10th of January, 15th of January, for instance, and he doesn't show up. As long as the mother has the affidavit of service to show the magistrate that, hey, he's being served, and he was served since early December, so he's had ample time to appear. He's refused to appear, hasn't sent any correspondence to the court to say that he's sick or can't make it for whatever reason. Then you would get an arrears worksheet and your affidavit of service, present those to the magistrate. Magistrate will see, okay, this person hasn't paid anything in December, for instance. and the magistrate is able to proceed in making an order for this person to pay. So let's go then to the committal. Section 55 speaks to committing someone to prison for not complying with a court order. So many of you would know there's an Airbnb in Fox Hill. Some people call it Her Majesty's Prison. Some people call it the Bahamas Department of Corrections. It's a wonderful Airbnb facility for anybody who does not want to comply with a court order. Room and board covered. All right, so you can be sentenced for up to 3 months at a time for failing to comply with the order. But truth be told, the norm is 14 to 21 days for the magistrates. Most of the times they'll say this person is committed to prison for 14 days or 21 days, okay? But a magistrate won't commit someone to prison if they're able to make an attachment of earnings order, okay? So this person is making money and the magistrate is able to make an order that the employer deduct from their salary and forward the funds for the child support, then that can be done. So that raises, before I pause, that raises two things we need to explain: willful refusal and culpable neglect. Willful refusal is when someone was working, this father was working, but he refused to pay child support. So the mother's application for child support that's filed, one of the things she needs to express in her affidavit or when she's in the witness stand is that this was a willful refusal, Your Honor. The father has been gainfully employed all this time. He was never unemployed during the pandemic, or he was unemployed during the slow season for tourism. He was always employed, and he refused to pay the child support. And with willful refusal, the magistrate will see that as a blatant disrespect to a court's order and the welfare of the child. Then there's the culpable neglect, where you weren't working, but you could have worked, You were working, but you chose not to. In other words, let's say you were a banker and you had lost your job during the pandemic, but you could have done something else. You could have washed cars, you could have sold fruits on the side of the road, you could have cleaned apartments, Airbnbs, you could have done tiling, plumbing, because you're skilled in those areas, but you've chosen not to do anything because it says beneath me, I'm not doing it. So your children went without for years. That is called culpable neglect. You neglected your kids and you could have done something, but you chose to do nothing. The court ordered you to pay $100, even if you went by every week with $25. It would have shown good faith, but you chose to do nothing. All right? So those are things the court will take into consideration. And based on that, I will then wrap up this session on child support with a quick recap. For those of you who are of the view that you can't be bothered with child support, understand that you have to think long term. If someone is ordered to pay $75 per week for the maintenance of one of your children, a child, in any given 12-year period, primary school and high school alone, that equates to about $46,000. By the time your child is graduating from high school, you would have had on an account every week and every year accumulating $75 a week to total, by the time this child finishes high school, $46,000, which will be able to help pay for college, buy this child a piece of property, or at least a down payment for the property, or help this child rent a place and start their own business. Think long term. I don't have any of my clients going to magistrate court to stand in line to wait for any funds. We do all of it by designated bank account. So when child support payments are due any given week, the father is ordered to transfer via a bank, his bank, to the wife's bank account. So she's never going to court to check on payments. So those days are done. You have the utmost privacy now with that. There's no more humiliation. You don't have to go to court. You can do a bank transfer, okay? So you'll get a notification on your phone, ping, your ex just sent you $75 on Friday, and every week, and you'll be able to go from your app and see all your banking statement to show he's been paying or that he hasn't been paying, all right? The gist of it is, if you are going to child support court, try to serve the person in ample time so that you can have a discussion to come to a consent order on the things this child needs, and the things the child will need are pretty basic, and it's common sense. You know the child needs breakfast, lunch, and dinner every Saturday and Sunday. You know on school days the child needs lunch money. Before the child goes to school, he needs breakfast. When the child gets home, he needs dinner. He or she needs dinner. You know the child needs clothing Every summer and Christmas, I think, is a reasonable time to replenish clothes. Every June, December. So December 1st, you should be purchasing a jacket for the child if they don't have one, long pants, long shirts, socks, etc. Every summer, you should make sure the child has short pants, t-shirts, etc. You also want to factor in that every child has to do certain vaccinations and medical visits, medical, dental, optical. These things are basic. Someone has to drop this child to school, that's gas. Somebody has to have an apartment for this child to live in, that's rent. Or if it's a house, mortgage. And these are things that you want to contribute towards and have a discussion on, but you want to be reasonable. So if one person says they want these things that are considered luxuries, like they want private school and extracurricular activities, that those things are arguable, and a court is not likely to give you luxuries, okay? And luxuries are private. If the government can provide it or it can be given free, same thing when it comes to medical. If the child can go to the clinic for dental work, but the mother insists that the child go to XYZ dental, where that visit is going to cost $100 and the medical procedure could cost another $150, so a $250 bill plus VAT. The court will say, well, no, the child can go public because this person doesn't have the means to contribute $250 towards that, all right? So things to consider. Regardless of anything I say today, I always remind persons that there is an act that can be found on, just Google lawsofthebahamas.com. It'll come up with the act, and the act for child support is called the Child Protection Act. And again, this session is being organized by the developers at everythinglocal.com. You can download the mobile app and you'll get these exclusive videos from many persons in various professions every given week, summarizing what they do, how they do it, and why they do it. And again, my name is Renard Henfield. I've been practicing for 19 years. I've studied law for 6 years, and I've been in Parliament for 1 term. Thank you.